Judicial independence is fundamental to our state and federal judiciary. Judges must continue to interrogate any predisposed beliefs that they might have and set them aside. Particularly as an intermediate appellate court, that means we apply the law as it is provided either by a higher court or by our legislature to the facts that we have in front of us.
The judicial branch operates independently from the other two branches of government, which is an essential part of the rule of law. In Washington state, the courts are structured in levels, ensuring that you have an independent review of your case. If you believe a lower court made a legal or procedural error, you have the right to appeal to a higher court. Before 1969, when the Court of Appeals was created, all appeals coming out of all superior courts went straight to the Supreme Court. This was an untenable system. So the Court of Appeals was created to take the bulk of the appeals so that the Supreme Court could better use its discretion when choosing which cases needed their interpretation.
The Washington State Court of Appeals is an intermediate appellate court that is positioned between our state superior courts and our state Supreme Court within our judiciary. We are one court with 3 geographic divisions. Division 1 is in downtown Seattle, Division 2 is headquartered in Tacoma, Division 3 is in Spokane. If folks have a criminal matter and they disagree with the outcome, they have the right to an appeal at public expense, both with regard to the filing and the preparation of the record, and as to representation. For civil matters, there is no right of appeal at public expense, but people self-fund those appeals and they pursue them. The percentage of the appeals that come from the superior courts that actually make their way through us, or sometimes around us, to the state Supreme Court is very, very small, because that allows them to focus on the issues that are truly of state constitutional magnitude and that will have a much broader impact. The reality is that the opinions issued in our cases are the final word on that case in the overwhelming majority of appeals that are heard in the state of Washington.
So, you have a right to appeal because you disagree with the outcome of your trial. But you can't just disagree. You must claim there was a legal or procedural error in your case, and you must file your appeal in a timely manner. At the Court of Appeals, there is no new evidence presented. There is no jury. There are no witnesses. But there is a plethora of documents that the court must examine.
We have either a verdict, again, a civil or a criminal case, we get a verdict. Sometimes we have written findings of fact and conclusions of law, but that record, that evidentiary record is created in the trial court and may not be created anew at the appellate court. All we're doing is looking at what happened in those earlier proceedings. We read the briefing of the parties where they're applying law to that record, so then we chase down the law. We look at the cases and the statutes they provide, but we do our own independent research. And especially where we are presented with a question of statutory interpretation, that is where we will get into the historical record. And we will look at, what did the statute look like before it was amended? And what were the discussions in our legislature about the purpose of those amendments? That helps us to determine legislative intent. The size of the record varies, but it can be anywhere from a couple of hundred pages to like in the tens of thousands. And that's the work that we do when we're not on the bench.
This objective, independent analysis of the trial court's record protects the rights of the appellant. Even the way the Court of Appeals is organized ensures an independent judiciary and a system that safeguards the rule of law.
So our case assignments are random. Our court administrator sets the docket, sets the panels of cases with the judges, and then each judge screens for conflicts checks to make sure that they don't have conflicts of interest. Some cases might be decided without oral argument. If this is actually a well-settled area of law, we don't necessarily need to hear from the parties in order to decide that case.
The court sits in panels of 3 judges.
I would say it doesn't.
The judges can interrupt the attorneys if they want their argument clarified or they question their legal reasoning. These exchanges help the judges write their opinions, which address the legal questions presented by the attorneys in their briefings.
For cases that have been set for oral argument, everyone's given a preset time limit. We do our best to hold them to time constraints. And part of that is for fairness, and part of it is for efficiency to run our own dockets. Parties can and do often ask for more time if they think the issues are complex. The panel will decide whether or not they think that's warranted.
Ultimately, each case will either be affirmed, meaning that the trial court's ruling stands, overturned, meaning that the trial court's verdict is thrown out, or the case may be remanded, which means that it's sent back to the trial court.
The person who has filed the appeal, the appellant, has the burden to demonstrate the errors that they are claiming. The question for us is, does that argument have merit that should result in reversal or some other sort of action that the appellant is seeking? So we analyze the question under the Constitution, the federal Constitution, the state Constitution, the relevant statute, the existing case law, that sort of thing. Just because someone makes an argument doesn't mean that it will be a persuasive one. It doesn't mean that it will be one that is supported by the law or the record. Hopefully, we're writing opinions that are accessible to every Washingtonian, that they can pick up and read and understand the relevant facts and understand the relevant law without needing specialized legal training. But there's so much nuance, and that's intentional. That is how our justice system is designed to work, that everyone's case is decided on its own unique facts, because that's what will get us closer to justice.